All right, thank you for having me. My paper is a little bit different, I think, than a number of the other papers. I guess it's somewhat in the vein of Dick Craswell's paper and trying to sort of make some general points and some observations about the debate between strict liability and fault in contract law. So I thought I'd start out by just giving some thoughts about what the debate is about, what really turns on it, because I think some people, including Eric yesterday, I think raised a legitimate question about how much of a difference does this really make, and it could be that the difference is not very much. One may be a difference on emphasis, and some of you may have noticed the best thing I like about my paper is the title, because it's an iambic pentameter. Which the only time I've ever been able to do that.
Man of the soul.
Yes. No, but the interesting thing is that there is someone who recognized that, at least implicitly, and that's Judge Posner. Because you'll notice his paper is also in 10 syllables, but the accent is on the first syllable. I don't know whether he did that intentionally or not. I bet he did. But I think it really is a good way of sort of highlighting the issue of emphasis. That is, it may in part be a question of what are you emphasizing? Are you emphasizing the strict liability part and then there are exceptions for fault, or are you emphasizing the fault part and there are exceptions for strict liability? Similar to the point that Stefan Grundmann was making yesterday as well. Sometimes I think that the question of emphasis can make a big difference in the way you characterize things. I know Judge Posner is going to talk about in his paper the idea that these labels can be misleading. Calling something bad faith is perhaps less informative than saying exploitation of situational monopoly or something like that. But sometimes it can cut the other way as well. That is, for example, there was a famous comment that Ken Arrow made on a famous paper about moral hazard by Mark Pauly, where Mark Pauly had made this observation that, well, moral hazard is just rational economic behavior. It's just someone doing a cost-benefit analysis and acting in a rational way. And Arrow says, well, yeah, that's true to some extent, but it's also, there is some justification calling it moral hazard. And then the sentence that he gave was, well, no doubt Judas Iscariot turned a tidy profit from one of his transactions, but the usual judgment of his behavior is not necessarily wrong. Which I think is a way of saying that there may be some value in these labels that we put on things too, and calling them just costs or benefits also has some implications that we may not always want to follow. So the question of emphasis is one question. The second might be a question of impact. That is, does it actually matter in individual cases whether we have say we have a strict liability system and have these exceptions, or say we have a system that's fault-based and have pockets of strict liability or whatever you want to call it. And probably in most cases, how you frame it doesn't make a huge amount of difference, but there may be some cases. I actually cite one case that I found kind of interesting from the Chancery Court in Delaware, this West Willow Bay case, where the court actually makes reference explicitly to the strict liability idea. It was a case where there was a commercial landlord that was selling a piece of property and had agreed or entered into a contract. One of the obligations of the contract was to secure tenant consent in connection with selling the property. And they weren't able to get tenant consent. And the question is, well, what's the consequence of that? And the court looks at the contract and says, it makes an argument that I think is perfectly plausible in a number of contexts, that, well, in other areas of the contract there were best efforts provisions put in, but not in this one. And so this one obviously must have been strict liability, because that's the general understanding of the contract. And so there was a strict liability obligation to do this, and so you have breached, and the court didn't really talk about damages. The court did say you couldn't get specific performance because you can't force them to get the tenants to consent. But the court, I think, was influenced by this idea, well, the contract's a strict liability, and so that's what we do, and that's the background norm, and the best efforts are the weird things. And so if you don't specifically say that, then we're going to assume strict liability. And so, there may be cases like that where it may actually make a difference what your background framework is about the nature of contract liability. And then the third aspect of the debate, I think, is the question of theoretical direction, which I think is much more focused on Bob Scott's paper, where I think he and I have some disagreements about about the way contract theory ought to go, and we've certainly talked about that, and I'm sorry he's not here to sort of defend his position. I'm sure Fabrizio will do an excellent job on that. But the so-called new formalism approaches to contract, which I think, and I think Bob's paper points that up, has some connections with the strict liability idea, and seems to be pushing more or asking us to push more in the direction of strict liability approaches. So my basic thesis is relatively simple, and it's I think congruent with a number of things that people have said yesterday and this morning, and that is that fault is an inherent and unavoidable part of contract law, and that's a good thing from both an economic perspective or other perspectives as well. And that the justifications that have been given for strict liability systems tend to rely on oversimplified notions of both contractual intent and fault. And that fault is not only unavoidable and inherent, but it's also pervasive. It's throughout contract law. It's not something where it's just limited to individual different areas. It's not maybe the starting point, but it sort of infuses itself in all aspects of contract law at different times, whether we're talking about the formation or the performance of the remedy. The focus in the conference here, for the most part, has been on performance and remedy, naturally, because performance is where we see the restatement and cases most emphatically endorsing the strict liability principle, and the remedy because of statements by Holmes and others that the reason for the reach doesn't matter in determining what remedies are, a view that I disagree with, but that's certainly a well understood statement. And then formation, where although it hasn't been talked about as much here, I think that there have been some references in some of the papers, but there it's the reason for failing to contract that is deemed not to matter. And so I think it's important to recognize that the fault ideas that come out in all these different areas, because that I think has relevance to several aspects of the argument in favor of strict liability. It's not, first of all, it's hard to sort of characterize, I think, a system as a strict liability system if fault pops up in other areas, sort of like what I like to refer to as the water balloon theory. You push the water down and it goes somewhere else. And so what's the point of saying, well, you have a no fault system just for performance, but not for these other things? It only really works if you're going to do it across the board. Okay, so I then talk a little bit in the paper about different justifications for strict liability, both what I call sort of vaguely traditional and economic kinds of approaches. Maybe unfairly, I don't really attribute the traditional approach to anyone, but the traditional approach seems to go something like the following. Contract, we've talked a lot about the distinction between contract and tort. The main idea is a contract's about intent, and tort is about something beyond the intention of the parties. Fault, social judgment of some kind or another. And interestingly enough, you look at the brochure that we put out for this conference. You have all these people pointing at one individual person. It's not a two-person thing, right? Which is what we usually think of as contracts. But there's a whole group, the whole society is pointing the finger at the wrongdoer, which is kind of the idea that this is a social judgment. It's not just an individualized concept of fault. And I think there's something to that, but it still leaves the question of, okay, well, if contract is about intent, how do we know what the intent of the parties is? How do we know that they don't really intend to incorporate fault-based liability? So that's one of the key questions. Now, the economists, I think, have an approach to fault, which basically says, well, we ought to look at what we think the parties would reasonably have done, and sort of impute that to the intention of the parties. That's how we figure out what intention is. And the way that can lead you to a strict liability system is to focus on several different things that I've summarized in the paper. You can focus on some version of the superior risk bearer, or whatever you want to call it, kind of theory, where you say, well, in general, on average, the promisor is the better risk bearer, precaution taker, mitigator, what have you, and that justifies strict liability because it's better to have, let's say, an across-the-board rule or something like that. You can focus on litigation costs, as a number of the papers do, that says that fault is always costly to litigate. You can say that you can focus on comparative institutional competence and say, well, the parties are better able to sort of figure out fault and incorporate it when they want to. And I think there are some problems with all of these kinds of arguments. The problem with the superior risk bearer is, as many of the papers here have pointed out, it's not always true that the promissor is the superior risk bearer, and to the extent that we can reasonably identify categories or other situations of cases where that's not true, it makes sense, or it stands to reason that you would have exceptions to strict liability that incorporate some aspect of fault. With respect to litigation costs, there's some ways in which that might be true, that the fault system is more costly to litigate, but I think Richard Epstein's paper and others, I think, demonstrate that that's not necessarily true either. You can have categories of behavior. You can have presumptions. You can focus on custom. Fault doesn't have to be, as I say in the paper, a free-for-all. And also, to the extent that fault shows up in lots of different areas of contract, the fact that you save some litigation costs on the question of performance, if you wind up litigating the same issues on damages or on, whether it's a divisible contract or a contract as a whole, you haven't really saved anything. It's one big case where everything is sort of litigated. And so what you have to say is, again, strict liability has to apply across the board in order to really recognize these savings, and that's not always true. Okay, so then what I try to do in the rest of the paper is talk a little bit about intent and what that means, or how one might understand that. The key idea here, I think, is the idea that intent is very often uncertain. And the best evidence of that is that we have contract law. That is, if intent was always easy to figure out, you could have one rule, which is sort of what I tell my students on the first day. There really is only one rule in contract law, right? You enforce the mutual intentions of the parties. And then the rest of the course is figuring out what that means. And that's what contract law is. Contract law is giving us sort of guidance, or giving courts guidance for figuring out how we figure out what the intentions of the parties are, with some exceptions. But that's the general idea of contract law. So how is intent uncertain? It's uncertain in a lot of ways. To sort of pick up on a variation of Dick Craswell's paper, right? You can focus on different aspects of intent. We talk about Jacob and Young's, right? Is the intent that matters the intent to have a well-built house, in which case there's no difference between the Cohos and the Redding? Is the intent to use Redding pipe, which is the way the dissent understands intent? That's the relevant intent. That's the only question. So if you frame intent that way, then it's an easy case for the dissent. So you can have differences not only in how you define willfulness, but how you define intent. Which kind of intent should we focus on? There are, as I point out in the paper, differences between what I refer to as primary and secondary intent. Right? There's the intent under the contract. What are we supposed to do or not do? And then there's the intent about how we should figure out what that intent is, which, as I said, is mostly what contract law is about. Sometimes contracts talk about that as well. We're going to give courts guidance. We're going to put in a merger clause that tells us how we want courts to figure out what our intent is. But if you have more than one intent or different kinds of intent, then you have to make another decision, which is which takes priority. Does one always take priority over the other, and how do you figure that out? So it complicates the question of intent. Yesterday, there were some people who talked about the fact that you have complicated projects where there's lots of different promises being made, construction being the sort of paradigm example. That also complicates the problem of intent. Something that I mentioned in the paper that people haven't talked about yet is that very often there are agency problems that create problems of intent, especially when you have different people who negotiate the contract, write the contract, enforce the contract, litigate on the contract, and there are a whole number of contracts cases where really why the dispute happens is because there's been a change in the agents, a change in management, or the analogy in the consideration cases, the promissor dies and you have the estate that's suing. So there's a change in the cast of characters. It's not one person sort of changing their mind, although that happens plenty of times as well. But how we ought to deal with that, how we ought to think about that situation is important as well. So once we complicate the idea of intent, then the supposed dichotomy of what I call the traditional view between fault and intent. Intent is about what the parties want, and fault is about some social judgment. It doesn't dissolve completely, but it becomes a lot more blurred. because now you can have all sorts of ways in which fault and intent can be perfectly consistent, not only because the parties may expressly adopt fault kinds of terms, but because it may make sense to imply intention to accept some kinds of fault judgments in different kinds of cases. And fault could be viewed as a tiebreaker. That is, fault can help us understand intent, not something that's consistent or completely dichotomous from intent. And so once we recognize that, then it's not that hard to say that it makes sense to view contract as an intent or a fault-based system. And it's only if you have a very strong idea of this is what the intention of the parties is, and I know it, and I know it with great certainty, then there becomes much more of a dichotomy. That's not to say that there aren't cases like that where parties explicitly say, we don't want intent to come in, we want a warranty, we want an option, right? This is part of the discussion with Sean the Schiffer yesterday, the debate about option. And this also, I think, goes in part to the question of emphasis and vocabulary. I think one of the interesting things about that debate, at least to me, is an option, I mean, that's very powerful rhetoric to call something an option. The reason it's powerful is because the usual idea of an option is you can not accept it for whatever reason you want. Good reason, bad reason, any reason. So it's like at-will employment and things like that. So saying something that a promise is an option, to me, has this inference that there aren't any excuses. I mean, there aren't any justifications, or there aren't any bad grounds for saying no. Where the discussion, I think, with Shauna yesterday was leading to a more nuanced view, which is that, well, no, there are some cases in which it makes sense to that is that there are some things that are taken off the table when you make a promise, and we can disagree, obviously, about what those are. But I think there's something to that idea. I try at the end to talk about different ways in which fault appears throughout contract doctrine, putting a little bit more emphasis on some aspects of formation than I have in the past, because I've talked about in other work, remedies and performance. One thing that I mention in particular, which I think is kind of interesting, is the rule of sections 20 and 201 of the Restatement, rules that you usually talk about in contracts in connection with the peerless case. That's section 20, which is really about, if you accept the court's understanding, that the parties have no meeting of the minds, that is, and that neither side is really at fault, where the Restatement endorses the view that there shouldn't be a contract at all. But the more interesting thing about both section 20 and 201, which is about interpretation, is that it endorses a kind of, explicitly, a kind of false standard in the idea of reason to know. If one person has reason to know what the other side wanted, that person's going to lose under section 20 and 201. And it's kind of interesting that there in sort of the foundational, two of the foundational sections, one might think, of the Restatement, although they're not heavily litigated, you have fault being explicitly written in to the doctrine. So that is, so I go through other examples in the paper, but I won't do that here. And then finally, just to finish up with two other points that I make, and then I'll stop. One is the sort of what I call, in a cutesy kind of way, I guess, what might be viewed as the court theorem, or the legal realist point, which is again a variation on the water balloon thing. The idea here being that it's, even if you wanted to, even if you thought that it was crazy to have a fault system, it would be very hard to eradicate it completely, because fault is sort of an inherent part of our normative world. Everyone makes judgments about good and bad behavior. That's how we live our lives. Judges are people like everyone else. They are going to be influenced by what they view as good and bad behavior. And if you sort of shut off one valve for them to let those notions come out, they will find some other way to do it. And I make a suggestion. I'm curious to hear what the game theorists think. But one of the interesting things that, or constraints, I think, of the game theory approach to some of these situations is that the courts are not viewed as participants in the game. They're viewed, basically the rules are set, and then it's the parties who are the contracting parties who are the players, and they sort of work out things, and then the courts just enforce whatever the the rule is. But the reality of the way law tends to work is that courts are sort of a part of the ongoing negotiations in some broader sense. They're really players. They're also responding to what people do, and if they see bad behavior going on, they smack it down, and that then becomes incorporated into the law. So that's my view of how fault is inevitable. It's going to come in whether we want it or not. It's not to say that strict liability has no role. I don't think that's true. I don't think one could possibly say that that's true. I think we have very strong impulses in the strict liability direction too. What I tried to suggest is one way to understand that is that we have very strong commitments to deterring certain kinds of opportunistic and other bad behaviors by promisors, and so strict liability is a way of expressing that view. But it is only, in my opinion, at most a presumption that can be overcome in a variety of different ways under different fault standards. Okay, so I'll stop. Yeah.
I was hoping you were going to get to Section 20 and 201 because I didn't want to sandbag you with something that was in your paper but not your talk.
Okay.
Let's talk about Lefkowitz.
Okay.
When Lefkowitz tries to go to the store the second Saturday to take to take the store up on, everybody kind of, I'm sorry, just for the sitting here videos, this is Lefkowitz's Minneapolis supply store, surplus store. You know, the ad, first come, first served, 9 a.m. Saturday morning. The first time he goes to the store tells him they have a store rule that the sales actually only available to female customers. They run a similar ad next week, different items, but same basic terms, and he shows up, and again, they turn him away. Russell Crockett and I have been kind of going back and forth on whether the court got it right or wrong, leaving aside whether the court explained it right or wrong, correctly or not. But his argument is that Lefkowitz should have known of the store's policy, and so shouldn't have assumed that he was able to accept the offer, assuming that the ad was an offer. My argument is that the store should have known of Lefkowitz's understanding of their ad, and they were in a position to change the language of the ad than all of the Lefkowitzes out there to understand that there was an unwritten rule that applied. What's your take on it?
What's my take on it? Okay, well, I mean,
you can side with Russell. It's okay.
No. I mean, it's kind of an interesting case, right? But I think that the debate is similar to. I mean, the debate you're having is, what would people reasonably expect this to mean, and would they expect that this would be something that would be specifically available to them? The general question is an advertisement and offer, kind of thing, and we talk about the idea that, well, in general, maybe they're not because they may run out and things of that sort. And you might say, well, okay, but maybe we should force make them offers and then force people to put in a disclaimer or a rainy day thing, or first come, first serve, put it in explicitly, which is what happens in Lefkowitz. So I mean, I think there are certainly arguments to be made about you could view it as a kind of precaution thing. You want to put the burden on the store to make their advertisements clearer or something like that. Or you could say, well, Lefkowitz should have reasonably understood that this is not going to be enforceable. So I think those things are debatable. What I think is interesting is that I think that those are the debates that we have. Right, the debates are about it's a kind of who's in a better position to have done something about it, and there could be reasonable disagreements about these in marginal kinds of cases. I mean, Leonard in the Pepsi, the Harrier Jet case is another example of that. Was Leonard a sort of sleazy guy because he was trying to, he knew that the Harrier Jet ad in Pepsi wasn't going to be enforceable, and so he's just, figuring he's going to get some money out of these guys, or was it Pepsi that's more at fault because they could easily fix it, right? So I mean, my particular view of something like that is that Leonard makes sense if you view Leonard as the sleazy guy, and Pepsi, they may have been negligent, but they weren't sleazy. They weren't trying to take advantage of him. And so if you sort of view Leonard as sort of the grabber, the unreasonable grabber, that case makes more sense. So I think that those cases raise those kinds of questions, just like the performance and the damages.
Yeah. Well, you discuss in the paper, and also you related to it in your presentation. So right, when there could be different justifications for strict liability in contracts, and you argue, among other things, that those justifications are not so inclusive. Right? And one of those the litigation costs, for example, and you say, well, this is not. And I guess that you can also look at torts and say, well, it works in torts, right? In torts, we know that it's a fault-based regime, so it could work. So probably the litigation costs are not so high. So even though strict liability may have some advantages there, the costs are not prohibitively high. So what I want to ask you is, actually it relates to, actually it was also discussed by Eric yesterday, more in the paper than in the presentation, which is the verifiability. Right now, verifiability, you could say that verifiability it's very close to litigation costs, right? Because if something is unverifiable, it means that you need more litigation to know what exactly happened there. And again, you could say, well, so there could be a problem of verification. Sometimes we don't know whether the breach was at fault or not. But the same thing would happen also in tort. Sometimes we don't know whether it was at fault or not. So it seems to be the same thing. Now, what I would like to ask, and to suggest, and to hear what you have to say about it, is that in fact there is some very substantial difference here between a breach on one side and a tort accident on the other side. Now, with a tort accident, usually what happens, when we can see an accident, on many occasions, just looking to the accident, you have a kind of a strong prima facie case of negligence. If somebody drives his car and hits someone, and it seems to have no special reason, there's a kind of a prima facie case of negligence. Maybe sometimes it can be rebutted, but in most of the cases it's relatively easy. And we also know that when courts apply the negligence standard in torts, they usually focus, when they don't look to activity level, for example, they just focus in the more immediate causes of the accidents. So it is relatively easy. And we also know from torts that they don't look at the activity level. So in order to influence activity level, strict liability, also in torts, is the solution, right? Sometimes if it's very important the problem of verification is really hard, then this is a possible justification to switch to strict liability. And I would like to suggest, and to hear what you have to say about it, that maybe in contracts it's different. Because usually what we see in contracts, we don't see kind of a tort accident. We just see non-performance. That's it. We can say nothing about it just by looking at it. And maybe on many occasions the inquiry is much more problematic, much more similar to activity level in torts, right? And exactly as in torts, we prefer strict liability. In those situations, we know that there is a verification problem. Maybe in contracts, this is the regular case, right? So the exception maybe in torts is the, right? I mean, so what do you think about these arguments? So the argument is that in contracts, in a breach of contract, the verification, to know whether it was at fault or not, to know whether it was efficient or inefficient breach, is much harder to verify comparing to a tort case. And that could be a justification why we see, after all, more strict liability in contracts than in torts.
All right, I have to think about that a little bit more. I mean, I think that, obviously you can complicate it in a variety of ways. And you can say in torts, yes, I mean, in many cases there is res ipsa loquitur, and the fact that there's an accident shows that someone must have been careless. But there are other cases where there's no necessary implication just from the fact of the accident that something may happen, that someone had to have been negligent somewhere, or someone had to have been at fault somewhere. So there are certainly cases like that. But you're making more of a generalization. I mean, on the contract side, I guess, you could say, to me, the way I think about it is, I think there's something to the idea that, the mere fact that non-performance has occurred is itself, you could view it as at least presumptively faulty behavior on the part of the promisor, right? That's sort of the traditional view, right? The breach is the wrong, kind of thing. And so, it's not exactly your point about verifiability, but maybe there's some connection there that, as a starting point, as a presumption, we ought to say, okay, well, look, there's a breach. Probably that means the promisor did something wrong, and we're not going to get into that one way or the other unless there's a good reason to. So we say, strict liability. All I want to say is, that may be true in a certain number of cases, but we should view it as what I call a fault-based presumption. That is, there should always be, and this is consistent, I think, with your paper, that there should always be a chance for the other side to say, okay, well, in general that may be true, but in this situation, it doesn't make sense because of X, Y, or Z reason. Now, and I believe that there are ways to limit that so that, as I said, it's not a complete, you can raise anything whatsoever under the sun, but there are categories of things at least that you can use to rebut, situations like in your paper or other kinds of things where it makes sense to allow some kind of rebuttal. Richard?
Yeah, my question is essentially to ask you to continue your answer in the following way, which is to actually do the demarcation. Your last remarks in the general presentation was that there's always a room for strict liability, and then the fault thing. And so I think what we want to have is a classification where the prima facie case is going to be one in some cases and then the other in another. And then also, since a lot of these cases involve not just the prima facie case, but much more complex situations like excuses for conditions, you might even have a merger stuff. And so I'm curious as to how you do it. To be more concrete about it, you've heard basically two efforts of classifications. On the one that Stefan gave and the one that I gave. His mainly on the service goods line, and mine the sort of fractionation inside the service class. And I'm just curious as to whether or not you think your approach would be consistent with, would compel the requirement of this thing, would be antithetical to the sorts of classification judgments that we made, even though they differed a little bit at the edges. I treat them essentially as concurrent or concordant. And are you going to join our anti-hand club, or are you going to find yourself a starting member or something else?
No, I'm very sympathetic to your position and the categories thing. I have to think more about, I read the paper, but I have to think more about, how closely I went. But I didn't see anything in the paper that I disagreed with that you wrote. So,
what about Stefan?
Well, no, and the goods thing I think is exactly right. I mean, to me, what I wrote about in my damages paper is that, I think, Holmes, in sort of typical judicial overstatement, basically made the statement about, the reason for the breach doesn't matter, but it makes perfect sense in the goods case, where there's fungible goods and perfect substitution and everything, because, as others have pointed out, essentially the contract market differential gets you all that you need, right? It discourages the breach to take advantage of a change in the market price, so it disgorges, as Thielen and Peter and said yesterday. It disgorges the gains, and it also, in line with what Saul said in his paper, encourages mitigation on the other side. It's the best of all possible worlds. So if you have this ideal, completely fungible goods situation, you don't need anything other than the market damage rule. And Holmes was exactly right in my view in that case. But the question is, what happens when you get beyond that case? When you go to the services cases where the presumption is sort of the other way, does Holmes carry over there? And I think that in some sense, we may have been too quick to sort of carry over that general theme to situations where I don't think it's as justified. Yeah.
Can I press you on what I think is going to be Dick's point later, which is I'm not quite sure I see when you're talking about Section 201 or Section 20 what work exactly the fault language is doing. In other words, you could interpret these cases. For example, there was a case last year from Delaware where you had two law firms negotiating with each other over $100 million agreement. Neither one of these people are nice people, but ultimately the court says there's a duty of the forthright negotiator, because one person understood there was an ambiguity in the contract, the other person didn't know there was an ambiguity in the contract. The court said, no, you know there's the ambiguity, you know the other person doesn't know the ambiguity. It makes sense for you to disclose or be responsible for the other person's interpretation. I don't think of that as fault. I just think of that as a sensible way to make sure that contracts are clear and parties know where they stand. And the more general point that I take it to be, we can use the word fault in these circumstances, but again, what we're trying to do is to come up with reasonable duties that are going to make everyone better off, and that attaching moral weight to it doesn't really have any cash value to it.
Okay, yeah. Well, I mean, the debate about whether you should sort of throw moral kind of language on it, I don't want to get into that debate so much. I mean, I think that the key thing is I don't disagree with you. I mean, I think that that's what you are trying to do in this case. So all I'm trying to say is whatever approach, I mean, that approach is not really a strict liability approach in the sense that, all you have to do is say, this person made this promise, this is what it means, or plain language, whatever you want to say. Why are courts asking, well, what did you know about what this person did? I mean, yeah, they're just trying to figure out intent, but all I'm suggesting is that there's some kind of fault component already built into that. In the same way that the objective theory of contract itself, to me, is really a fault-based idea. That is, why wouldn't we allow a subjective view to prevail? Well, there are a couple of reasons. One is, if you manifest intent and someone is misled, maybe you are somehow negligent in having misled someone into thinking there was a contract. Or maybe you're just lying now that was your subjective intent. But that's the opportunistic story. So under both stories, the objective theory makes sense. Where it doesn't make sense, or where it makes less sense, is where those presumptions aren't true. So there are people who've criticized sections 20 and 201 as being inconsistent with the objective theory. And my argument is they're not really consistent at all if you understand the objective theory as essentially a fault-based presumption that can be overcome in certain kinds of situations. If someone did know that the other person meant X, and then they figured, oh well, I can sort of sneak around that and ignore that and go on my merry way. So and if you don't want to call that fault, okay. All I'm saying is that there is some kind of fault component built into it, and I think it's useful.
So you're using the word fault.
Okay.
That's what I don't. You're saying if you don't want to use the word fault, that's okay.
Mm-hmm.
Okay. I'm saying we can talk about all these things without getting moral blameworthiness or anything else. We're simply coming up with sensible, off-the-rack interpretations that have some standard-like characteristics.
Right. But all right. And all right. So what I think I'm saying is that you are trying to, in doing that, both encourage and discourage certain kinds of behaviors, and that to me
that's
is
what we always do. Right?
Yes. Well, I think, but I think there's a difference between that and having sort of approaches that basically don't focus on exactly was this good or bad behavior, but was there problems, was it breach, and that's the end of it. I'm just trying to make it a little bit more, or argue that it's a little bit more complicated than just that.
Well, let me extend Douglas's point in the form of a sort of friendly suggestion about future work.
Mm-hmm.
I mean, you've established, not just in this paper, but in earlier articles, that there are these pockets of fault in contract law, and in some sense I certainly agree with that, and it's a very useful thing to have shown. But as this conference has also shown, fault can be used in all kinds of different ways. There's moral notions of fault, there's economic notions of fault, there's different economic notions of fault, the Bernard-Pan formula type fault, or Richard's ordinary care type fault, lots of others. So it seems to me that the next project on your agenda ought to be, having identified these various pockets of fault, go back now and identify which kind of fault is involved in each of those pockets. Some of them we may end up saying aren't fault under any of the definitions, in which case maybe we should take those pockets off. I think we've got enough definitions of fault out there that probably they're all going to be fault under one definition or another, but that's sort of the problem. That until we get down to the next level of saying, well, this is fault in the following sense, and this pocket over here is fault in this specific sense, I think would really be the way to carry this forward.
By the way, Neil Eisenberg, in his paper that he contributed to the volume, not to the, he's not here, actually have tried to take upon himself this.
Is there a way we can get that? It's not linked on the conference page.
Sure, and it's written, of course.
Yeah, I think that's certainly a fair suggestion. The only thing that I would just sort of add is that I think that it is useful to be clear about what exactly you're talking about. So I take that suggestion and that criticism. I also think, though, that it's possible to, as I think was suggested yesterday in discussing your paper, it's possible to walk and chew gum at the same time. That is, that it's possible to have different kinds of fault going on. It's not an illegitimate move to say, well, this could be faulty under a number of different scenarios, and in fact, the more ways in which something could be characterized as faulty, the stronger the case that there is something wrong with it and it ought to be discovered. So I think that there's some usefulness there. Despite what Richard said about overlap, I think that at least in this case, overlap might make the case stronger in some cases. But I take the point more generally that it is useful, I think, to be clear. So,
an observation and then a question. The observation is, I think I would feel better about the evolving dichotomy between fault and strict liability pieces of contract if it tied in better to our experience about where people can buy insurance. And I don't really see that in any of the work, and maybe that's something that needs to happen in the future.
Absolutely.
Right, I mean, it almost seems, random, and that just doesn't sound right.
Yes.
I
Well,
mean, you would have thought that, just to make sure we're on the same page, you would have thought that where pockets of fault were more predominant, it was because people wanted to choose whether to buy the insurance component or not. On the other hand, if everybody wanted the insurance, then it made sense, if only on a transaction cost basis, to provide strict liability through the contract. I don't see any connection between these areas, and that worries me a little bit. That's the observation. The question is this: you think the following is in your favor or against you? So, we're brought up to think the strict liability in contracts, and now, some of us, you have convinced some people, and other people have convinced people that there are pockets of fault, and that maybe you can be first syllable, you can be penultimate or not, accent of sorts. But here's what's going to happen to you when you start aging. You're then going to say, oh, wait, I have a new discovery. There are areas that are neither strict liability nor fault. They're like sub-fault. We don't give a hoot. As long as you try, courts play around with damages and remedies and other things. And there are a lot of areas like that. You go to a private school, you sign your kid up for a private school, and they say, I guess they don't say, we promise your kid can go to college, or even we promise your kid can read. But they must be promising something. Maybe they promise they'll try, and then people bring these seemingly crazy litigations. Well, my kid reads less now than before first grade. You haven't tried at all. No, we really don't expect damages at all. Airports. You go there and you buy your ticket to San Diego, and there's no strict liability and there's no fault. It's way sub-fault. But even if it turns out that the airlines did everything wrong, you're not getting recovery. So if you start adding up those areas of law where it's, I don't know what to call it, sub-fault, and you're going to say, aha, you see, this shows that I'm even more right, contracts is not strict liability, it's other things, or are you going to start feeling this shows that I'm wrong because it's not exactly that it's fault. It's not fault that's growing, it's like there are a lot of sort of things out there.
okay. Well, yeah, that's a good question. I think law is always fighting the last war to some degree. That is, you're always responding to, sort of what's the problem of the day, and what have the existing rules, wrought in terms of what people's incentives are now. And so, I think that there's always going to be some room for sort of, smacking down the excesses of whatever the previous theories or underlying, principles were. So, I mean, that's just my view of how law develops. So it's not surprising that, maybe you have people now, some people like Bob Scott arguing for more strict liability because he thinks that there were too many excesses in the former, Carl Llewellyn world of, contextualism or something like that. So he's, saying, look, we went too far in that direction. So we're, so then, if Bob Scott's view prevails, then 50 years now there'll be another Llewellyn who says that was wrong. So I think these things are, it's not so much cyclical as, whatever view that prevails, you're going to wind up with excesses perhaps in that direction, and then there's going to be sort of a backlash in the other direction. So and I think that there are some areas where norms are evolving. We're still in a relatively new area in the airlines about how people still are pissed off at things that the airlines do, and I think over time we may get better understandings about how how we want to resolve those things and what the appropriate responses should be. So I don't have definitive answers right now for one or the other, but that's my general answer. That I think that we're always going to be responding to the prior misbehavior of whether it's theoretical or not. The insurance point I think is a very interesting one because it's something else that no one I think has talked about in the conference, and we talked about outside the conference, but is I think a really interesting phenomenon for the whole conference, and that is the bailout situation. And I think insurance is very prominent there. So in my view about insurance, one of the interesting things with insurance is that for lots of different areas, I mean, breach of contract technically was not insurable. Insurance companies don't tend to do it. I mean, they insure business interruption and different aspects of contract, but just the contract itself tend not to be things that insurance companies get involved in. And I think for traditional reasons of moral hazard, it's hard to figure out what these things are. But I mean, this is very important for the bailout because of the credit derivative swaps, right? Which people talk about as an insurance market. And what happened with the credit derivative swaps? Well, there's two important aspects to me that are different between credit derivative swaps and other insurance. These are the bond, the insurance on the derivatives and the mortgage-backed securities, right? So one is that you can overinsure, right? There's no limit. It's like being, having a house that's worth, $100,000 and you're insured for $1 million. We don't let you do that in regular insurance, but in the credit derivative swaps you can. And then you don't have to have an insurable interest either, right? You don't have to have any property interest in the security. So it's basically purely betting, which is not exactly purely betting because there are people who can influence the likelihood of the risk happening one way or the other. And that's it's not the full explanation of what went wrong, but it's certainly something else. So I think thinking about the insurance is exactly one of the right questions that we should be asking.
But I think we are off time.
Okay.
Thank you very much.